1. Walter Raleigh's execution, the hearsay rule and confrontation clause. Picture 1603. Sir Walter Raleigh, Elizabethan explorer, writer, and alleged conspirator, is put on trial for treason against King James I. The Crown's key evidence is a letter from Lord Cobham, accusing Raleigh of participating in a plot to overthrow the king. But Cobham never appears in court. No cross-examination. No questioning. Just a letter. Raleigh demands that Cobham be brought before him. He even calls the trial a trial by the Spanish Inquisition, for relying on accusations he can't confront. The judges brush him off. The jury convicts him in 15 minutes. Years later, Raleigh is executed on those same unchallenged claims. The injustice of this became a legal cautionary tale across the English-speaking world. Common law courts responded by developing the hearsay rule, the principle that out-of-court statements offered to prove the truth of the matter asserted are generally inadmissible. When the American founders drafted the Sixth Amendment, they didn't forget Raleigh. The Confrontation Clause, to be confronted with the witnesses against him, was a direct response to that kind of railroading. Fast forward centuries, and this is why, in modern trials, the prosecution can't just dump affidavits or second-hand accusations on a jury. Someone has to get on the stand and face the defendant. Raleigh's farce of a trial basically wrote one of the bedrock rules of modern evidence law. 2. Farmer grows too much wheat, Wickard versus Filburn, 1942. Roscoe Filburn was a farmer in Ohio during the New Deal era. Under the Agricultural Adjustment Act, the federal government limited how much wheat farmers could grow to stabilize prices. Filburn grew more than his allotment, but here's the kicker. The extra wheat was for his own personal use on the farm. He didn't sell it. He didn't ship it. It never crossed state lines. The government fined him anyway. Filburn argued this was absurd. If the Constitution gives Congress power to regulate interstate commerce, how does wheat grown, stored, and consumed on one farm qualify? The Supreme Court, in Wickard versus Filburn, gave Congress the broadest interpretation of the Commerce Clause in U.S. history. They ruled that even if an activity is local and not itself commerce, Congress can regulate it if, taken in the aggregate, it would substantially affect interstate commerce. Translation: Filburn's wheat may seem small, but if every farmer did the same, it would affect the national wheat market. That was enough to bring him under federal regulation. This case basically turbocharged federal power. Post-Wickard, Congress could regulate almost anything with a plausible economic ripple effect. Environmental law, civil rights law, labor law, all eventually leaned on Wickard's logic. 3. Police seize papers without a warrant. Weeks versus United States, 1914. Fremont Weeks ran a lottery through the U.S. mail. Federal officers suspected him, entered his home without a warrant, and seized letters and papers. They handed them to federal prosecutors, who used the evidence to convict him. Weeks appealed to the Supreme Court, arguing that this was a blatant violation of the Fourth Amendment. And the court agreed. In Weeks versus United States, the justices held that evidence obtained through an unconstitutional search and seizure cannot be used in federal court. This was the birth of the exclusionary rule in American law. Before this, the Fourth Amendment was more like a polite suggestion. After Weeks, it had teeth. Violate it, and your evidence gets tossed. Important note, this applied only to federal cases. It wasn't until Mapp versus Ohio in 1961 that the exclusionary rule was applied to the states through incorporation. But Weeks set the foundation. It was the first time the Supreme Court told the government, you don't get to break the Constitution to win. 4. Illegal gambling in a phone booth. Katz versus United States, 1967. Charles Katz ran an illegal bookmaking operation. He'd step into a public phone booth, close the door, and make his calls. The FBI, rather than physically entering the booth, bugged the outside with a recording device. They caught his conversations without a warrant. Katz argued this was an illegal search. The government said, "Come on, it's a public phone booth. We didn't even step inside." The Supreme Court flipped the traditional trespass doctrine on its head. In Katz versus United States, Justice Harlan's concurrence laid out what became the reasonable expectation of privacy test. The person must exhibit an actual, subjective expectation of privacy. Society must recognize that expectation as reasonable. Katz shut the door, lowered his voice. He expected privacy. And society agreed that phone conversations, even in public booths, are private. Therefore, the FBI's recording was a search, and without a warrant, unconstitutional. Katz basically dragged the Fourth Amendment into the modern era, beyond property lines and physical trespass. It's the case that underpins modern wiretap laws, surveillance litigation, and the legal battles over government eavesdropping in the digital age. 5. Terry stopped on the street, Terry vs. Ohio, 1968. Cleveland, 1963. Detective Martin McFadden sees three men pacing back and forth, peering into a store window, whispering to each other. It looks like they're casing the joint for a robbery. He approaches, identifies himself as a cop, and does a quick pat-down of one of them, John Terry, finding a concealed revolver. Terry moves to suppress the gun, arguing that the officer lacked probable cause for an arrest or a full search. The Supreme Court, in Terry vs. Ohio, carved out a brand new category of police action: the stop and frisk. They ruled that if an officer has reasonable suspicion, a lower standard than probable cause, that a person is involved in criminal activity and may be armed, they can briefly detain and pat them down for weapons. This ruling dramatically expanded police power, allowing officers to intervene proactively. It became the legal backbone of countless street encounters and, decades later, the controversial stop and frisk policies in cities like New York. Terry fundamentally altered how the Fourth Amendment applies in everyday policing. 6. Ernesto Miranda confesses, Miranda vs. Arizona, 1966. 1963. Phoenix. Ernesto Miranda is arrested in connection with a kidnapping and rape. He's interrogated for 2 hours, signs a confession, and is convicted. But he was never told he had the right to remain silent or to consult a lawyer. The Supreme Court consolidated Miranda's case with a few others involving coercive interrogations and, in Miranda vs. Arizona, announced a bold rule. Before custodial interrogation, police must inform suspects of their Fifth Amendment rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You know the rest. Miranda's conviction was overturned, though he was retried and convicted based on other evidence. Ironically, years later he was stabbed to death, and the suspect exercised his Miranda rights and never confessed. Miranda fundamentally reshaped American criminal procedure. It took abstract constitutional protections and turned them into a script officers must follow, making the Fifth Amendment something every American knows by heart.